Welcome to U.S. Taxes TV. I am Jillian Breakspear of the CPA firm of Lord Breakspear Callahan, located in Miami, Florida. Today, we'll be having a discussion on FATCA, which is the Foreign Account Tax Compliance Act, and the effect that it can have on you as an individual. We'd like to thank the Gleaner and digjamaica.com for hosting this forum. Joining me today for the discussion is Sean Wolf of the law firm of Packman Newell Rosenberg and Alfredo Tamayo. This firm is located in Coral Gables, Florida, and is one of the most respected firms in the state of Florida for international taxation. Sean is a graduate of the University of Miami Law School with an LLM in taxation. He has been recognized as a rising star by Florida Super Lawyers and is listed in the best lawyers in America and Florida for tax law. He is also certified with a specialization in tax law. Alfredo is a graduate of Villanova University Law School with an LLM in taxation and is the authority on FATCA at Packman Newell and Rosenberg. In addition, Alfredo is also a certified public accountant. I would also like to introduce you to my colleague, Jose Huerta, of the CPA firm of Lord Breakspear Callahan. Jose is a graduate of Florida International University with a Bachelor of Accounting and an Executive Master's in Taxation. Jose has 9 years of experience in the areas of inbound and outbound international taxation, income tax compliance for U.S. citizens, permanent residents, and foreign nationals. If during this presentation you have any questions, please email us by going to the Contact Us section below on your screen. There are certain documents and forms that we will refer to during the presentation. If you go to the Documents section below, you will find these documents under the tab of FATCA Seminar Documents. This webcast is not intended as professional, whether legal or accounting advice, and the application of the U.S. tax law to particular client situations are fact-intensive. You should seek U.S. tax professional with which to discuss the specifics of your situation. If you do not have a tax advisor, feel free to contact the presenters of this webcast. It will be our pleasure to assist. So let's begin. Alfredo, could you please give us your feelings as to why the U.S. government introduced FATCA?
Sure. Well, first off, good morning. All right. Essentially, the U.S. government passed FATCA in the simplest of terms to go ahead and cover a loophole that existed under prior law. And what I mean by that can be demonstrated in what happened with UBS and the governmental actions that the U.S. took against that particular financial institution. What people used to do, certain U.S. citizens or U.S. taxpayers used to try to go ahead and establish entities to go ahead and basically hide their accounts and hide their identity from being reported to the U.S. government. So under prior law, there was an arguable position that those individual taxpayers who actually owned those entities didn't have to actually disclose their own personal identities to the government as being beneficial owners of these accounts. So in light of that, the U.S. government wanted more transparency and has basically passed FATCA to be able to look behind these foreign entities. U.S. government also saw it as a way to go ahead and obviously raise additional revenues because FATCA was passed at a time when the economic crisis was really hitting back in 2010.
Thank you, Alfredo. Now, Alfredo, we know that FATCA, that governments have signed intergovernmental agreements. And I was wondering if you'd go over with us what the different types of agreements are, and then specifically, what type of agreement Jamaica has.
Sure. Just a very brief background. When FATCA was enacted back in 2010, it was a unilateral approach, meaning the U.S. government was dictating what it wanted the world's financial institutions to do. Obviously, that didn't make the world very happy, and it caused a lot of problems. One of them being that a lot of different foreign countries have certain secrecy laws, certain privacy laws, that even if you had a financial institution in a particular country that wanted to come in compliance with FATCA, it would be prohibited under local law from exchanging information or reporting information directly to the U.S. government. So as a way around that, there is this intergovernmental agreement approach, which basically means that you can get the U.S. government signing off on an agreement with a foreign country such as Jamaica, where both parties agree to enact FATCA. Okay, and by enacting this particular intergovernmental agreement, it'll go ahead and solve local law issues in terms of exchange of information or secrecy laws. Okay, so under this approach, it's basically enacting FATCA in one of two major types of agreements. There are Model 1 and Model 2 agreements. Jamaica has what's called a Model 1 agreement. What that essentially means is that there's going to be an exchange of information between the U.S. and Jamaica. And that'll be done on an automatic basis and on an annual basis.
So, Alfredo, you said an automatic exchange of information. By that, you mean a reciprocal agreement?
Correct.
And what exactly does that mean?
Okay. So essentially what that means is all the financial institutions in Jamaica are going to be required to conduct certain, what we call due diligence. They're going to be looking for certain U.S. indicia, mailing addresses, if any one of their account holders has U.S. passports, U.S. phone numbers, certain U.S. indicia to determine whether these people may be account holders who are from the U.S. Okay? There's a specific procedure that these financial institutions will do to complete that due diligence. Okay? Once that is completed and once there are U.S. account holders who are identified, those financial institutions are going to be required to report those account holders to the Jamaican Tax Authority, who will then exchange that information directly with the Internal Revenue Service. Okay, and what the U.S. government has agreed to do is to have its U.S. financial institutions also conduct certain due diligence about any Jamaican account holders that they may be maintaining accounts for, and providing certain information about those Jamaican account holders back to the Jamaican government. So that is the reciprocal exchange of information.
That's very interesting. And I think the Jamaican taxpayer needs to be aware of that and to seek advice as to what that means for them.
Well, if I could jump in, just Alfredo.
Sure.
You mentioned two things that I'd ask you to follow up on. One, what's the form or what is the bank going to be asking of people? And two, I think there might be a misconception about people that are dual citizens or dual residents. Can you maybe clarify that here?
Sure. So let's talk about that. So right now, Jamaica has this, what we call this intergovernmental agreement in place. Mm-hmm. So at this time, if account holders haven't already heard about it, they'll probably be getting contact from their Jamaican financial institutions with some follow-up questions, or even asked to fill out certain forms, what we call these W8 BEN forms. Mm-hmm. Okay. The impact to individuals is specifically that. They're going to have to go ahead and document what their status is, whether they're actually considered U.S. or whether they're considered non-residents of the U.S. for tax purposes. Why? Because obviously if you have a non-resident of the U.S. who has an account in Jamaica, as long as they go ahead and certify that fact and it's true, there's nothing else for them to do from a FATCA point of view.
So let me ask you, Alfredo, does this mean the effect of FATCA on the individual is merely their reporting requirement to the financial institution?
Yeah, it's pretty much documenting their status.
Okay.
All right, and that'll typically be done on a W8 BEN form.
Okay.
Now, if you happen to be U.S., there will be a W9 form that Jose will talk about in a little more detail. Mm-hmm. That they'll need to provide to the financial institution, providing their name, address, and social security number, and that'll be used by the financial institution in Jamaica to, help report and become compliant with FATCA.
But if you're a dual, does that mean anything? Yeah.
Now, dual, there's a common misconception that if you're a dual national and you just provide your Jamaican passport to your financial institution, that's going to wipe you clean for FATCA purposes, and that is absolutely incorrect. No. The fact that you are a U.S. citizen is enough for you to be considered a U.S. taxpayer.
What about a U.S. green card holder also?
Same thing.
Okay.
All right, and that's absolutely essential.
Okay. Jose, your turn. Alfredo has talked about the W9 and the W8. And could you explain more about this to us and what it entails and the information that's going to be required to complete these forms?
Yeah, sure. First of all, forms WA and W9 has been around for a long time, but they just were outdated because of FATCA. In the case of Form W9, which is the request for taxpayer identification number and certification, is used by payees to certify that the taxpayer identification number is correct and that they are a U.S. person. On August 29, 2013, the IRS released a new Form W9 where there is now a certification of FATCA status. The instructions of the form are very clear and defines who is exempt from FATCA. On the other hand, we have the Forms WA that are to be completed by foreign persons to certify that they are not U.S. persons. The IRS has issued updates and Forms WA as of February 2014 to accommodate the FATCA certifications similar to Form W9. Now, Forms WA has been divided into forms. The first one, which is the WA-BEN, which is the Certificate of Foreign Status of Beneficial Owners of United States Tax Withholding and Reporting. This form is mainly for individuals where they basically will be providing the information to certify that they are not U.S. persons. The other form is the WA-BENE, which is basically the form that certifies that the entities are not U.S. entities. This form, basically the foreign entity needs to provide information just to make sure that they are not required to be compliant with the laws of FATCA.
Thank you, Jose. So, Jose, with these requirements now, what have you been hearing back from our clients about having to make relationships with foreign entities? What feedback have you been getting? Because I just got a really interesting article from the Daily Tax Report about what's been happening because of FATCA, to people with their relationships, business relationships, banking relationships, financial institution relationships.
Yes,
Could you give
Julia.
us some feedback on what our clients are saying?
Yeah, sure. Basically, many Americans residing overseas are reporting banking lockout. A number of foreign financial institutions have simply chosen to eliminate the accounts of U.S. citizens and the U.S. companies in order to minimize the FATCA reporting requirements, withholding, fees, and any potential penalties. This is causing a lot of problems for U.S. citizens and companies doing business overseas. As you just mentioned, there is this article saying that as of September 15, there was a poll conducted of 6,500 U.S. citizens, and one of every six person that was interviewed or went through a survey mentioned that they have a problem with a foreign bank or a brokerage house that had closed the account because of FATCA. And many of them are struggling to find a banking relationship in the countries where they are residing. So.
Well, also what should be noticed is that these people that gave the responses are people that are living out of the country, so they're actually getting this feedback. This is real feedback.
If I could ask
Yeah,
Alfredo to clarify something, because is the bank's reaction really getting them out of FATCA by telling U.S. people not to be there? And maybe you can also clarify what if the bank is not FATCA compliant, what does that mean to even non-U.S. people? Because there is a consequence.
Yeah, so I've also heard that there are a lot of foreign financial institutions who are basically closing the accounts of their U.S. account holders. That's their knee-jerk reaction to FATCA. Their thinking is, okay, we don't want to deal with the complexity of FATCA, and if we have no account holders here, within our institution who are U.S., we can avoid the problem. Well, that's not necessarily correct, because what FATCA comes down to is if you have any type of U.S. source investments, that's the trigger. Okay, it's not necessarily the nationality or the tax residence of the particular account holder that drives whether or not FATCA applies. And under general FATCA law, there's a 30% withholding tax that would otherwise apply if you have a financial institution that isn't compliant. What could that mean to the financial institution's customers? Well, obviously, they're going to get 30% less of whatever their U.S. source type income that they would otherwise be receiving indirectly from the financial institution that they would receive. So that's certainly a consequence. And at the end of the day, that particular financial institution who is reacting that way, is going to lose out on business because there are going to be many other financial institutions who are already taking steps to become compliant, whether it's registering or taking necessary steps to become compliant and communicate with their clients about it.
But let me go one step further, because we had a client that came to us and said that he met with a group of foreigners that they were going to do a business deal.
Yeah.
And when they found out that he was an American, they said, I'm sorry, we don't want to do business with you because of the complexity of the reporting requirements.
Sure.
Can you give us a little bit more insight into that, please, Sean?
Well, I mean, I think, we've heard that, several times. And the answer is, that's not entirely right. Just because there is a U.S. person involved in the ownership, or, and I know one particular situation that I'm thinking of where it wasn't even about ownership, it was about having the person being an officer or a director. The answer is yes, they may have to do some compliance and file some forms in the United States. But to make decisions to not have U.S. people in a business because it may cause some filings, I mean, that's something that people are going to have to deal with and face. But, that's sort of letting the tax tail wag the dog, which seems to not make good business sense. If it makes good business sense to have a person there, then you may just have to deal with the fact that there's some reporting that may have to be done. But it's not incredibly burdensome, and that's where we'll talk about some of the forms.
Forms,
as we go
definitely.
through.
Because, by the way, we were just talking about the W8 and W9. Please remember to go to the document section. You're going to be able to pull up these documents and review them yourself.
But I
Okay.
guess just to hit the point home, the point is that you could, if you go to a bank that is not FATCA compliant and you are not a U.S. person, you could have 30% withheld that not necessarily is required to be paid as tax. And you could be finding yourself having to file a tax return to request a refund
Of that 30%?
of the 30%. So, I
Wow.
mean, so for example, it may not apply right now, but Alfredo, maybe you should just touch
Can
on
you
real
give us
quick.
some, yeah.
What about capital gains?
Yeah, so the way the withholding regime is working is that it's going to be phased in over time. Right now, we're typically just talking about interest and dividends, and even interest that would be otherwise exempt from general withholding under other provisions of the law, like bank interest. A lot of non-residents have personal accounts, and they do that obviously because one reason being the interest income isn't
That's
subject to U.S. tax. FATCA changes that. If that particular account holder isn't properly documented, they could be facing a 30% withholding tax under general FATCA law.
And in the and going forward, as it's implemented, it could even apply to capital gains, which
Correct.
are also not subject to tax.
Correct. So you could be looking, for instance, at bonds, which again, the interest could be exempt from tax under.
There's 30% withholding on it.
Yeah, there
Or
could
the
be.
sale of IBM stock.
Yeah, so you could be looking at a 30% withholding on the interest income, and then when you go ahead and redeem that bond, the sales proceeds could be subject to.
Through the 30% withholding.
Yeah.
That's rough. Okay, now, Alfredo, you were talking about the W8s and W9s. And I think very importantly, where is this information going? What is happening to it?
Okay, so under.
And let's talk about in general, and then let's be specific with regard to Jamaica.
Okay, well, in general, any country that has an intergovernmental agreement in place, these Model 1 type intergovernmental agreements, the financial institutions of those foreign countries will be collecting information about their U.S. account holders and providing that to their local tax authority. So in this case, when we're talking about Jamaica, we're talking about the tax administration in Jamaica. Okay, and then the tax administration in Jamaica is going to go ahead and provide that information to the IRS. So there's essentially a buffer, is what this intergovernmental agreement provides. Rather than having the financial institutions in Jamaica report directly to the IRS and enter into agreements with the IRS to become compliant, the Jamaican government has negotiated this Model 1 agreement so that at least the Jamaican government is serving as a buffer so that its financial institutions don't have to comply directly with the IRS. So that's where the information is going. The information that we're talking about, basic information like name, identification number, address, account numbers, the financial institution where the account is held. Those are the basic information that are being disclosed.
So, Alfredo, all I can imagine is when the IRS gets these documents, it's all being loaded into those massive computers and being matched with everything and spitting out a lot of information that the IRS is going to be very interested in.
Yeah, basically what in the U.S. at least, we have what's called a matching system. Because obviously all our taxpayers voluntarily, on the honor system, go ahead and prepare their tax returns and submit it into the IRS, okay? As a check, the IRS requires third-party reporting. So for instance, I'm employed here, I earn wages. My employer is going to go ahead and report my wages directly to the IRS into their massive computer system that you're talking about. When I file my return and the IRS receives it, there's supposed to be an automated process where my tax return is going to be compared to this third-party reporting. So if I'm talking about wages, and that's all I'm reporting for a particular year, a certain amount of money, the IRS is going to expect to see that match whatever my employer has gone ahead and reported. Okay, so that's our matching system in the simplest terms. Obviously, foreign financial institutions don't go by that same system, but what FATCA is trying to do is try to get it there. So essentially, what the IRS is probably going to do is once they receive this information from the different governments like Jamaica, they're going to go ahead and take a look and match that up against what U.S. tax returns have been prepared by Jamaicans who happen to be U.S. citizens or taxpayers. And if there's a disconnect of some sort, if something doesn't match, it may prompt an inquiry. Okay, so the bottom line is, FATCA, when people talk about FATCA, obviously one of the issues that come up is compliance.
If I can, as the non-accountant at the table, I'll
Lucky
share.
you, Sean.
No, I'm going to share a personal, because I'm sure there's people that are watching this that are going, you have to be kidding me. There's no way this matching system really works. And I'll be the person that throws on the table and says, I had some student loan interest forgiven after making a certain number of payments on my student loans. I never received the form that the student loan company submitted to the government. So I didn't do anything. Well, I ended up getting 2 years later, a notice from the IRS saying you owe a certain amount of tax because we received this form
That you were forgiven.
and it was forgiven. And so, and I ended up, and so the matching system does work.
It does. So this is what FATCA comes down to, is that it's open Pandora's box for compliance.
Yes.
And it's stating now that these people that are U.S. citizens, green card holders, there are other circumstances that we're going to talk about here, they have got to get into a compliant situation. So, Sean, can you tell us who the U.S. government considers to be a U.S. taxpayer? This is so important because these individuals need to ensure that they are in compliance. And as we know, it's always said, ignorance is no excuse of the law.
Well, there's 3 tests that we can talk about. 2 of them are specific and involve an immigration status. 1 of them does not. So the first answer is, are you a U.S. citizen? Okay, and sometimes that can be an interesting question to ask. If you're born in the United States, generally you're going to be a U.S. citizen. There's exceptions to that. If there's anyone that has a doubt as to whether or not they have U.S. citizenship status, that should be confirmed with an immigration attorney. So U.S. citizens subject to worldwide income tax, does not matter where you live, does not matter if you have never stepped foot in the United States. If you are a U.S. citizen, you have to file and pay your taxes and report all these forms. The second classic example is the green card holder, the person that has lawful permanent residence status from the United States. As relevant to Jamaica, my understanding is there are many Jamaicans that have this status because they came to the United States, obtained a green card when there were certain issues in the country, and when things became better, they left the United States and returned home and put their green card in the drawer. Now, I can tell you the number of times we've had this call. I got my green card 30 years ago. I got my green card in 1980. I was in the United States for a year, maybe 2 years, and then things changed in Jamaica. I returned to Jamaica with my green card. I put it in a drawer. I've never come back to the United States. I'm not a U.S. person, right? The answer is wrong. You still have your green card. Okay, the U.S., even though immigration, if you ever used it, might take it from you, the tax law says because you did not properly abandon it, that you are still a U.S. income tax resident. And then people may want to know, well, properly how to abandon. We'll talk about that, a little bit later. The third test is a little bit more complicated. I'll talk about it in general, and we could really get into some details if we wanted, but it's a number of days test. And the number of days test generally looks at the current year and says, have you spent 183 days in the United States in the current year? Yes or no? If the answer is yes, you're a U.S. income tax resident. If the answer is no, then there's a second test. And the second test looks at the number of days you spent in the United States over 3 years, the current year and the prior 2. And there's a formula that you have to apply. And when you apply this formula, the prior year counts 1/3, the year before that counts 1/6. You add those together. If that comes up to 183 or more, you are a U.S. income tax resident. Now, there's several exceptions. And, some of them are, one of the most important one is if you have a medical condition that arose in the United States that precludes you from leaving, those days don't count. If you're here as a student and you have a student visa, those days don't count. So there's some very important exceptions. But there's also some very important exceptions that don't exist that I think it's very, very important to mention. The first one is, what if the medical condition arose in, let's say, Jamaica, and I come to the United States for medical treatment? Well, is that different than having the medical condition arise in the United States? And the answer is yes. So if a medical condition arises in Jamaica and you come here for treatment, those days count toward this test. A lot of people are surprised. I was very surprised when I actually went to the Cayman Islands, and I was told by the former Minister of Health that in Cayman they do not have a very strong cancer facility. And most of the people will come to the United States for treatment. And if the cancer arose in the Cayman Islands, those days count. So it's a very surprising thing. The second really surprising thing that people are surprised about is there's no act of God exception. So living here, Jamaica's more than aware of what the damage hurricanes can do. South Florida, all that much more aware. And so the answer is, if you're on the way to the airport to leave and you're counting your days and you're running through this test, and a hurricane comes along and shuts the airport down, and you didn't get to leave in time, there is no exception for that. So we have citizenship, we have having a green card, and we have, did you spend too many days here? The other important exception that I just put out there, that's very important, relevant to especially Jamaica, we have, if you do spend too many days, you can use a treaty to override that. But in order to use some of these exceptions, treaty, there's another one called the closer connection tax home exception. If I really live in a different country and I didn't spend too many days, the 183, a lot of very technical things. But the most important thing for people to realize is it's not automatic. You have to file forms to claim these exceptions. So if you violate this rule, you can't just say, no tax due, no problem. You actually have to file the forms. Without filing, you become an income tax resident in the United States.
It's tough, Sean. Then what about, we hear about accidental U.S. citizens. Somebody is from Canada, the mother comes across the border and gives birth and goes right back to Canada.
With the baby.
With the baby. The baby never comes back to the United States.
Or it can even happen where you don't even have to come to the United States. If you have, you can have the right set of facts where you have a U.S. citizen mother, and you can give birth outside of the United States. And there can be situations where U.S. people have their status and they don't know it. Accidental citizens are no different.
That's correct. They have to apply by the same rules.
Absolutely. U.S. citizenship is U.S. citizenship. And what can often make that even worse is that when you start talking about a minor child, you may not be able to get rid of your citizenship until you become an adult.
That's right.
And so it's a very interesting problem that people are very surprised to find out about.
So, Sean, somebody finds out that they are a U.S. taxpayer. And what do they have to do at this point now to get into compliance with the U.S. tax laws? Because this is very important for us to go through and be very clear on.
Yeah, and it's a very good thing. But there's a number of different ways to come into compliance. What has to happen is the person that found out that they have this obligation to file, you now have to prepare the tax returns that were due. There's different ways and different theories on how to do this. And as you mentioned in your opening remarks, that's a very fact-sensitive determination. So let me start with the one that a lot of people would probably guess is available. Oh, I really didn't know that I had to file. I'm an accidental citizen. I had no idea I should ever file. Can't I just file some forms for a couple years and write a letter that says I'm sorry? And the answer is yes, that's an available method. What you're really trying to rely on there is what's called reasonable cause. And in a situation like that, we might talk about filing back returns for 6 years. Okay? But I'd stop and I'd say, well, that may not even be the way that we would do things anymore. Because if you really had reasonable cause, you also were probably what's called non-willful. Now, I'm not going to get into what it means to be non-willful in this discussion, but if it was an accident, if it was a misunderstanding of the law, if it was confusion, if it was a number of things, but it wasn't you intentionally saying to the U.S. government, I just don't want to file, then there is a program, what they refer to as the Streamlined Offshore Voluntary Disclosure Program, which only requires you to file 3 years of income tax returns, and it requires you to do 6 years of these bank account forms that everybody has heard about, the FBAR, okay? And if you do that and you pay your taxes, if there's any due, there's no penalty. It's a very easy way for people to come forward. If you
Sean, this is
really
very
live,
different.
if you really live outside of the United States, okay? And it's very different because
From
this
what
is
we
something
have
that
to.
was only introduced in July of this
That's
year.
right. It was so different before. It was.
Well, we'll
it
talk
was a
about
major job
what's
before.
worse.
I know.
They even have a program for people that live in the United States. So if you are someone who spends too many days in the United States and you really live here, which again, there's lots of detailed tests we'd have to go through, you have the ability to come in under this streamlined program for people that live in the United States. Very similar terms of what you have to file, but now you have to deal with what a 5% penalty on what's referred to as your unreported offshore assets. So for example, if you had an unreported offshore bank account that had $1 million in it at the highest value during the 6 years, you could be subject to a 5% penalty. Now that again is a very simple way to come in, but it's for people who are not willful. And that is a determination that has to be really analyzed because it's not easy always to figure out who's willful, who's not. For the people who are more clearly willful, there's still a way to fix the problem. And this goes back to what you said about in the past. It was tough.
It was.
But the U.S. let's take I guess this is where I would take a step back and say let's go back to what Alfredo brought up. Let's go back to, I'll even go back further than that. How did we get to where we are with the U.S. government being so tough on these forms and the filings? Let's go back to it's all we're just past the anniversary of it. Let's go back to airplanes flying into buildings in New York, and the U.S. government saying, how did the money to fund this get into the United States? Right. And the U.S. started implementing laws to make it more difficult and to track things. And that's when the government started to realize there was this bank account form that was out there that was required. It's been there for many, many years. And they finally started saying, let's get that involved. Let's start looking at that. Then what happened? There was a wonderful company named Enron, represented by one of the largest accounting firms in the world at the time. And it had hundreds of companies it didn't report. And the government said, how is this possible? Okay, then what happens? UBS in 2009. And now the government is the U.S. government is just dumbfounded that there could be this level of non-compliance in the world. And so the government has gotten now, and that was when the first version of this voluntary disclosure program was implemented, was 2009. We're now in 2014. So what I want everybody to understand is when I tell you the terms of this program in 2014, it has gone through several iterations, and the government has gotten to the point that if you are someone who is willful, they are much more tough now. So what's the general idea of this program? And I'm saying, oh, willful. So yes, you have the possibility of criminal prosecution. That is something that if you are not in compliance with the U.S. tax law that is out there, criminal prosecution. But in order to do that, you have to be willful. You had to be someone that really violated the law in a really bad way with intent. And then you get to, so how, if I had that, if I am somebody who maybe is the person that went the wrong direction, how do I fix it? Well, the first step is what we have to do is we have to make sure that the government doesn't already have your name. So what we generally do is we go through a pre-clearance process. Now, in the past, that was a little bit more easy.
Yep.
Basically only required name, social security number, address, some basic information. As of July 1st, now you have to already start telling them about the bank accounts that and the assets that you didn't report. But the whole process is to see, does the government already have your name? Assuming the government doesn't already have your name, about 45 days later, that's probably about what we're seeing, that you'll get a letter that says, welcome to the program. You're allowed to keep moving and do a more formal application. That more formal application is generally due 45 days later. That's going to give a lot more information about the accounts, the assets that were unreported, the people that you dealt with and who may have helped you structure it. And assuming you give all of that information, about 30 days after that, you'll get another letter that says, you're formally welcome to the program. And what it really says is, as long as you do what you're required to do, file your returns, pay your taxes, and anything we ask you to do that you live up to, we're not interested in prosecuting you. So now you have the letter you put under your pillow that allows you to sleep at night, because now the IRS is not going to come at you criminally. It's all about money.
And how many years are we talking about there?
Well, that's what I was going to get, exactly.
Perfect.
Now, you have to file your tax returns. So now we're to the tax return problem. So I told you before, under the streamlined, if you were not willful, we would talk about 3 years of tax returns and 6 years of this FBAR form. If you tried to mail in returns, I told you we would generally talk about 6 years of both. In this program, you talk about going back 8 years.
I know.
8 years of income tax returns and 8 years of the FBARs. And now we talk about penalties. Okay, and again, there's exceptions, there's a whole bunch of issues. The main penalty is 27.5% of the unreported offshore assets. 27.5%. And starting on August 4th, the U.S. government said, and if any of those offshore assets were at banks, they had a list of about, what, 10?
Yeah.
I think it's about 10.
Yeah.
UBS is one. Credit Suisse was another. There was a bank in Jamaica.
First Caribbean.
Yeah,
First
there were,
Caribbean.
there were about 2 or 3 of them, I think we looked at.
And so there's a number of these of entities that are on this list that if you had accounts there that are unreported, the penalty jumps to 50% of the highest balance of the accounts.
Right.
So it's not going, it's not necessarily a cheap thing to clean up. But the most important thing is, if you're not willful, it may not cost too much, it can be fixed. If you are willful, it can be fixed without criminal sanctions. And money, you can make more of. Freedom, you can't. And then some people may say, what about me? I didn't underreport income. I filed all my, I was using Lord Breakspear. I filed the returns. I made a mistake. I didn't get this FBAR in on time, but I've paid all my taxes. Does that make me a criminal? Isn't there a simplified thing? Do I really have to go through all of this? And the answer is, if you paid all your taxes, and if you have reasonable cause in certain situations for not filing your forms, there's even another procedure that says maybe all you have to do is submit what was omitted, write a little letter about why it is that you haven't put, why you didn't file, and there won't be any penalties because you've paid your taxes. And again, it becomes a very simple process. So depending on where you fall in the scope of this, your compliance could be completely different.
Okay. Well, we've certainly gone through, and we know that it stands out there that there can be massive civil penalties and also exposure to criminal prosecution,
Well,
which is a serious thing.
and maybe what I need to even explain, which is some people may be watching this saying, why would I ever pay 50% of the highest balance of my account? Why is that a good deal? Mm-hmm. And it might be, other than to say that you have this potential for criminal prosecution. The next issue would be, well, what are the penalties without this program? Yeah. And that's where I'd say you could have, in a non-willful situation, for not filing bank accounts, a penalty of $10,000 per bank account per year. Mm-hmm. Okay? For not reporting certain offshore companies or entities, partnerships, different things, $10,000 per company per year per shareholder. So imagine a family of 5 people that are all U.S. people that own an entity. Mm-hmm. You could have a $50,000 penalty per year.
That's correct.
Okay? Then add to that, what happens if it's willful? So in the willful situation, wow, that failure to file that bank account form can be the greater of $100,000 per year, or 50% of the account. Greater of. So imagine a 6-year compliance period where there's $10 million in an account. If it's 50% of the account per year, that's $5 million per year, times 6 years, that's $30 million of a penalty that's due on a $10 million account. All of a sudden, 150% penalty sounds pretty good, doesn't it? That's what you have to be worried about. Have we as professionals ever seen that penalty imposed? No. Is it in the law, and can it be imposed? Yes. The answer is yes. And that's why when you start looking at this program, particularly when you have those willful facts, when you've been in the, when you've been at those banks, or, you have the process of looking willful, you have a problem. And that's where I would just tie back, and Alfredo, I guess I'd look to you and say, you brought up earlier people that have 2 passports. Yeah. So, I mean, somebody walks in and says, I'm Jamaican, and they forget to tell that they have a green card, especially now in light of FATCA. But I'd be saying to someone that's listening, you have to understand that if you go into one of these programs, or even if you don't, the U.S. can get these bank records. Mm-hmm. And the records that they have at these banks, they will keep every email, they will keep notes on every phone call, they will keep details that nobody is probably expecting to be there. That's right. And when you walk in and all you've given is your Jamaican passport, and you mark the box, no, I'm not a U.S. person,
that's fraud. Right.
You have now started to walk down that path of being willful. Mm-hmm. That's right. And that is, particularly now in light of FATCA, the answer is going to be when they ask that question and that W-8 comes to you or the W-9 comes to you and you're a U.S. person and you knowingly fill that form in wrong,
you're in trouble.
You now can be in that willful category. And that's scary.
So
I also want to mention that, most of these forms are only information or reporting requirements. It doesn't have any tax implications. Most of those forms. So it's just a matter of, being in compliance, and you will avoid those, nightmares.
So Jose, explain to us what is required, what information we are required to get from clients to be, to be compliant. I know that we cross-examine people totally when they come in here, and you have a terrible reputation for that, down to the little eensy-beensy item. What exactly do we ask them for?
Yes, Julie. There are many reporting requirements for, U.S. persons with foreign assets. Just going to cover the most common ones. The information we will need from taxpayer will vary based on their compliance requirements. If the taxpayer doesn't know their filing requirements, we are more than happy to, assist them with the determination of the filing requirements.
Jose, if I
yes.
can interrupt for a second.
Sure.
If it's someone who has never filed and who's in the position of they don't know if they're willful, non-willful, I just want to bring up something that's very important, a distinction between the accountant and the lawyer in the United States, and then I'll let you continue.
Sure.
CPAs, accountants, accounting professionals have a duty of confidentiality, which means if we were all out at a bar, you're not going to tell me about your clients. We have the same duty of confidentiality. I'm not going to tell you about our clients. The difference is we have a thing called privilege, which means that when we are spoken to, that if the IRS knocked on our door and asked us to hand over records about clients that have talked to us, the answer is get a court order. If they come to you and ask you about your clients, the answer is, well, here's our records.
That's why.
So please understand that if you are going to, if somebody has not filed and they're going to talk to a professional, make sure that you have an attorney involved who can have that privilege protected. So I apologize to interrupt, but I thought it was an important
that's
place
Oh,
to
no,
put
that's
that.
very important. That's why we always, if we have the least trepidation, we always say to our client, we are going to have to seek legal advice on this. So,
Okay,
thank
back
you,
to you.
Jose.
All right. For example, I'm just going to mention one of the most common reporting requirements. The taxpayer has foreign bank accounts outside the United States where they have either signature authority or financial interest, and the combined balance on those accounts at any time during the year is over $10,000. We will need to request all the bank statements from those accounts in order for us to determine the highest balance during the year. This information will be used to prepare Form FinCEN 114, which is the Report of Foreign Bank and Financial Accounts. This form used to be called TDF 90-22.1. Then when we this information, I mean the FinCEN 114 is controlled by the Financial Crimes Enforcement Network, which is a bureau of the United States Treasury Department, where they basically collect and analyze information about financial transactions in order to, like Sean mentioned before, to combat domestic and international money laundering, terrorism, financing, and other financial crimes. The U.S. government takes the filing of this form very seriously, and as Sean explained before, there are material penalties for non-compliance. The same information is requested for Form 8938, which is the statement of specified foreign financial assets. This form, we have different thresholds for reporting that are based on the value of the taxpayer specified foreign financial assets. What is an specified foreign financial asset? This includes financial accounts with foreign financial institutions and other non-account investment assets. For example, another requirement is the taxpayer owns more than 10% interest in a foreign corporation or in a foreign partnership. They will need to prepare forms 5471 or 8865. Basically, on those forms, we will need to request the financial statements of the entities. We will need to probably convert them from the local currency into US dollars and then convert it into US GAAP. On those forms, we will basically reporting financial information of the entity, who are the owners of the entities, and these forms is only an information reported requirement, but sometimes may trigger US income tax. Also, if you have foreign wages, you may need, in the case of Jamaica, provide to us the Form P24, so we can include that on your income tax returns. Also, any statements related to interest income, dividends, capital gains, and other forms of income. Also, the copies of your foreign tax return will be required in order for us to take advantage of foreign tax credit that may be available. There is also another common requirement. If you are a U.S. citizen and you get gifts from a foreign person, once this gift goes over $100,000 a year, this needs to be reported to the IRS. There is no tax implication to it, but this needs to be reported. So that's basically, most of the common reported requirements.
Well, if I could add a couple things.
Sure.
If you're the U.S. settlor of a foreign trust, you may have to file. You may have to file a form. If you're the beneficiary of a foreign trust and you're a U.S. person, there are forms to file. You brought up the Form 5471, and the 10% ownership is sort of one of the common.
The common, yes.
But you could be a U.S. person director, going back to your question earlier.
Or an officer.
That
too, so.
if you're an officer or director, you could be required. If you become a U.S. person, you get your green card. When you own interests in an offshore company, you can be required. If you own less than 10%, but yet your foreign spouse or your father or your mother own certain interests, there can be filing requirements. So it is a very complicated web, which is why I think it's fair to say we've all heard people that live outside of the United States come to us and say, I didn't understand all this. I mean, because it is really complicated. And that's why having tax professionals' help is almost required when you have some of the things that are out there.
That's why I think we should say that if anybody has any doubts or any questions, please feel free. If you don't have U.S. tax advisors, contact us. We'll be happy to assist.
Let me ask,
So-
let me ask you a question, Jose, because
Sure.
I think it's an important thing to clarify, because we've heard this in our office an innumerable number of times. I heard that if I make less than a certain amount of money working in Jamaica, I don't have to pay any taxes in the United States. I know that that is a true statement, but what do you have to do?
Well, basically, that's what Sean is talking about, is what is called the foreign income exclusion, that basically allows you meet certain requirements to exclude from your U.S. income tax the first, I think last year was like $97,600. So, but you need to meet certain requirements. Your tax home, which is basically the place where you reside and work, needs to be outside the U.S., and you also need to meet any other requirement, which is the the other two is the physical present test or the bona fide residence test. Once you meet those requirements, then you are able to exclude from U.S. income the first $97,600 that you make. But then you need to report. It's not that
You gotta prove it.
That's
Yeah.
the key. You
gotta prove
have
it.
to file a form,
That's
because
right.
that is probably one of the most misunderstood misconceptions that I hear from people. I made $50,000. I didn't file. I don't have to file, right? And the answer is wrong. You had to file.
yeah, in order for you to get this benefit, it needs to be reported on a tax return or on a particular form on a tax return. Too.
I think
So-
that's something that we have got to cover. We're running low on time here. And, you know, we hear about a lot of, and we hear this from our clients too, is my goodness, it's becoming so complex. I want to give up my citizenship. I want to give up my green card. How do they do that? What are the consequences?
Well, you know, and I'll answer it. I'll answer part of it, and part of it I'll say an immigration lawyer needs to give the answer. One part of it is, you know, it's not very difficult to give up your citizenship or give up green card. It involves filling out some forms, going to the U.S. Consulate or the U.S. Embassy, going through an interview process. They may tell you to leave and come back because they want to make sure that, you know, in giving that up, it's a really personal and serious decision. But that's the immigration side of it. And I've had innumerable people come to me and say, "Oh, well, you know, I was told I could do it, and I just went and did that paperwork, and I didn't think about any tax issues, didn't know there were tax issues." Well, now there's since 2008, our current rules are in place, and now we have what's called an exit tax. And what that exit tax really does is it asks 3 questions. You have to answer 3 questions, and yes, I know it'll surprise everyone that's watching. That means you have to file a form. So you have to answer these 3 questions. Am I worth more, $2 million or more? What was my average tax liability over the prior 5 years? And can I certify under penalties of perjury that I'm in full compliance with the U.S. tax law for the prior 5 years? If you answer any of those questions wrong meaning I'm worth more than $2 million, wrong meaning that my average liability is above a certain number, tax liability, and no, I'm not in compliance, any one of those answered wrong means you're called what's called a covered expatriate. We could spend 50 minutes just going over the detailed rules of what that means, but I will give you the 2 most important things. The first is that you will be deemed to have sold everything you own, and you basically have to pay tax on it as if it was sold, even though you didn't. There are certain exceptions. There's a threshold that I think is currently about $660,000 of gain that's excluded, but you have to know that it's real, it's serious, and it can have a surprising income tax consequence. That is not the most important problem. The most important problem is that there's a code section that is mostly looked over, which is to say that you will now be considered, you don't have to pay estate tax when you die, but your children who are U.S. do. They will now pay an inheritance tax. And the real important point of this is that if I could tie out how critical this can be, you could have a green card holder who lives in Jamaica full time and has all Jamaican assets. And if that person died because of the technical application of our rules, holding the green card, they'd owe no U.S. estate tax in that example. All Jamaican assets, lives in Jamaica 100% of the time, but has a green card. But if that person gave up their green card the wrong way, this rule that I just mentioned would say that when the U.S. people inherit from that person, there now is a tax where there never should have been one. So if someone wants to give up their green card or their citizenship, it's a very important decision that needs to be analyzed and made sure that it's followed. I'd add one more thing to say there's actually another rule that a lot of people aren't aware of that says that if you spend a certain amount of time in the United States over a 3-year period, and then you leave the United States. So let's say that you move to the United States, you come here, you work for a U.S. company and they give you stock. And you heard that, oh, if I'm foreign, stock isn't subject to tax in the United States. So why don't I just leave the United States? I don't have a green card. I just spent too many days here. I was on a work visa. I'll leave the United States for a year, not violate that test Sean mentioned, sell my stock, it'll be tax-free, and then I can move back. Yeah, the government thought of that one. Okay, so understand there's even more special rules that can apply even if you're not a green card or a citizen, but you try to play the I'll leave for a little bit and come back game. So there's a lot of complexity.
So gentlemen, we're tying down to an hour here. And what I'd like to do is just let's have a little wrap up here of everything and what you feel are the important points. You know, would you like to start with this, Alfredo?
Yeah, sure. I guess the most important wrap-up is just be aware, if you happen to be a Jamaican who's also U.S. citizen or a green card holder, just be aware that you're compliant with your U.S. tax and reporting, because if you're not, FATCA may trigger that inquiry. Because you're going to be getting a lot of questions from your financial institutions to certify your status, and reporting is going to start taking place between Jamaica and the U.S. on what they call U.S. reportable accounts. So now would be the time, if you have any questions or any uncertainty about your reporting obligations, now's the time to start reviewing them.
I think what I'd add to that is, just to tie it out, I think a lot of people would be very surprised to find out, and that's where I'll ask you a question, Jose. Imagine you have a family and you have a U.S. citizen child that lives in the United States, and they come to one of us and they say, yeah, I have bank accounts, I have signature authority on bank accounts, but they belong to my mother and father who live in Jamaica. Yeah. Or, oh yeah, I'm a 10% owner in a company, I have to file this form, but the other people that own it are my parents or my brothers and sisters that are in Jamaica, and guess what? They all have green cards. What do these forms require?
Well, no, definitely require full disclosure of who the owners are, and of course, when this child that lives in the U.S. wants to do the right thing and get into compliance, he will have to report the name of the family that hasn't been in compliance. So that's what I mean. Once again, ignorance of the laws is not an excuse to comply, not to comply, and I mean we just encourage everybody to get into compliance before FATCA gets fully implemented next year when they start sharing the information. But
what's really problematic is that's where now what happens is these forms almost put family members
at one another.
Because now the people, the father and the mother and the brother and the sister who live in Jamaica look at themselves as Jamaicans and go, I shouldn't have to be filing this form.
That's correct.
But now the person that lives here ends up putting them. It's not FATCA that is now putting them in front of the IRS. It's the child or the brother or the sister or the whoever's living here in the United States. So it's they have to understand that FATCA is going. If FATCA doesn't find them, there's other ways that the government may, and that's really important to be brought up.
Absolutely.
So my last question was, people may feel I'm 1 in a million. How am I going to get caught? But the world has become so complex and interrelated that we would really and truly recommend that you seek assistance and get into compliance. Gentlemen, we have reached 1 hour. We've gotten in a lot of questions, But I think that we need to stop at this point, or else it becomes, do you want to take some questions?
We
Or,
we can take
you
some
know, it's
questions
really
if
and
there
truly
are.
the, you know, well, the one question we have a lot of is exactly what you covered there, Sean, which was, you know, I have a joint account with my daughter in Jamaica. I'm a U.S. person. What's going to happen with this? And I think we've covered a lot of it. And what we're going to do is we'll go through the questions, and we will see what the situation is there, and we can answer them. We can email people back with any
Yeah,
questions
that's
that they may have. So, you know, we're going to say thank you very much. We appreciate you being, coming for this transmission, and we've come to the conclusion. I want to thank all of you for tuning in. I also want to thank Sean, Alfredo, and Jose for this seminar. I'd also like to thank Livus Technologies for doing the transmission. We would also like to thank digjamaica.com and the Gleaner for sponsoring this forum, and we do hope that we've been able to provide useful information and to answer any questions. In the following days, we will be providing more videos on demand with useful information for you, your family, and your business again. Thank you for watching.